So how much control does a local community have over medical marijuana?
That's the test the state Supreme Court will supply the answer to. 24-hour News 8's Joe LaFurgey has more on the debate tonight.
It is something that could affect your neighborhood and on both sides of the fence. Those who under state law are allowed the use of medical marijuana and those who want some sort of medical marijuana restrictions or controls.
Some of which appear to penalize or prohibit medical marijuana to some extent or the other.
The city of Wyoming is front and center in this debate. Last year, the State Court of Appeals ruled against the city after resident John Terbeek, a retired attorney and licensed medical marijuana user, argued Wyoming's adoption of a zoning ordinance restricting medical marijuana growth amounts to a ban on something state voters approved, a state law which appears to specifically exclude local laws from preempting it.
This is arguably preemption language, isn't it?
It doesn't use that term, but...
So we have to use a magic word now. The people in an initiative have to use magic words. Really?
I think you do.
Wyoming City Attorney Jack Slider's basic argument: there can be rules regulating activity, even if it's considered legal, and that the medical marijuana law doesn't specifically rule out the use of local zoning laws.
What they fail to say that allows you to say, we still have the authority under our zoning act to do what Wyoming did.
Because all we're saying is where you can do it.
The other question: does the State Medical Marijuana Act, or MMA, violate federal law prohibiting marijuana use? No, argues an American Civil Liberties Union lawyer, which has taken up the Wyoming resident's case.
And I think it's absolutely clear that nothing in the MMMA either does or seeks to block federal law enforcement of our marijuana laws.
No word on when the High Court will decide. In Grand Rapids, Joe LaFurgey, 24-hour News 8.